Okay, we have a CLE program now. And to do the introductions, I'm turning this over to our past president, Kyle Schicchetti.
Thank you, President Tollefson. As the Board of Governors knows, we passed a resolution in November of 2021 to commit to regular DEI trainings. Over this last year, we have been honored to have various people come to our Board of Governors meetings to present on different topics, including women in the law, LGBTQ plus legal professionals, and racial justice in Spokane. Today, I'm pleased to introduce our presenters who will speak about the basics of disability awareness, ADA misconceptions into the greater context of the disability rights movement. Since my involvement on the board for the past 5 years, I don't recall that we ever had any kind of training on disability awareness. And I'm glad that we have this opportunity. It was one of the areas that I was most interested in because we don't hear so much about it. So I'm glad we have two presenters here today to give us information and training on this important topic. Today's presentation has been improved for 1 law and legal procedure credit. Chief Singleton is going to put a link in the chat for you to sign up. There's also a sign in at the door, so you can sign in there if you want the CLE credits. Now I'm honored to introduce our speakers. We have Conrad Reynoldson, who founded the disability rights law firm, Washington Civil and Disability Advocate, and is a member of the Washington Attorneys with Disabilities Association. And Dustin Bowker, who is a legal intern at Washington Civil and Disability Advocate and a rising 2L at the University of Washington School of Law. So please join me in welcoming Conrad and Dustin.
All right, thank you for that introduction. So today's presentation, I like to refer to as the ADA Misconceptions presentation. So in the interest of time, I think I will go ahead and skip the intro slides for both of us and jump right into the presentation. Okay, so first off, some initial definitions, because I think definitional clarity is important in any discussion, including this one. So first off, the term impairment. What is an impairment? So one definition of an impairment is an injury, illness, or congenital condition that causes or is likely to cause a loss or difference of physiological or psychological function. Next slide, please. Now, what is a disability? Fitting for this presentation today. So one definition, for example, from the Americans with Disabilities Act of a disability is or an individual with a disability, I should say, is an individual who has a physical or mental impairment that substantially limits a major life activity, has a record of such an impairment, or is regarded as having such an impairment. At the time we put this information together, there were approximately 67 US acts or programs with definitions of disability, and 35 have self-contained definitions. Some have more than one. However, socially, the definition of disability can be very complicated and takes into account a number of factors, including community experience, history of oppression, family pride, history, civil rights. There's many different things that go into it. However, for today's presentation, we'll be using the disability studies definition, which is the loss or limitation of opportunities to take part in society on an equal level with others due to social and environmental barriers. So now I'm going to hand off to Dustin for a short exercise.
All right. Thank you very much, Conrad. And so And so we have prepared an exercise intended as a practice to differentiate impairment versus disability. And so on the picture on the left is a picture of Dr. Phil during the Dr. Phil show. And with a caption that says, nearly 62% of all American children are born with hooves and a full head of hair. And so the picture on the right is a picture of a person using a wheelchair in front of some stairs. And so, Diana, if you can open up the first question. For those on Zoom, you should see a question. What is the disability? So the first question is, what is the disability? For the first picture, the Dr. Phil picture, is it poor captioning, being unable? Well, is it poor captioning or being unable to hear? Or is it being unable to see? Or is it Dr. Phil? So for those on Zoom, please take a moment to answer that question. Okay, we good? Okay. All right, so.
Group vote our question. We need to respond and volunteer.
Yes. Yeah, so yeah, show of hands too. Who thinks poor captioning is the disability in the Dr. Phil picture? Okay. How about being unable to hear? All right. Okay. How about being unable to see? Okay. All right. How about Dr. Phil? Okay. Okay, okay. So the correct answer to that question is actually poor captioning, because poor captioning is the environmental barrier that is consistent with the disability studies definition of disability in this particular circumstance. All right, and so Dan, if you can pull up the next question. All right. Yeah, so for those of you who answered poor captioning on Zoom, that yes, that is the disability in this circumstance. Okay, and so Dan, if you can pull up the next question, please. Same photo on what is the impairment? And so for those of you on Zoom, take a moment to answer that question, please. For those in person, let's go over this. So who thinks Dr. Phil is the impairment in this case? Okay. How about being unable to hear? Okay. All right. How about being unable to see? All right. And how about poor captioning? Okay. All right. So the answer to that question is being unable to hear, and it looks like for those on, looks like the majority got that correct, 77%. It looks like. So yes, being unable to hear is more in line with a person's condition as opposed to an environmental barrier. So being unable to hear is the impairment in this photo. And so we'll switch over to the next photo with the wheelchair in front of some stairs. And so Diana, if you can pull up the next question, please. Kind of the same drill as the last photo. This next question is, what is the disability? For those on Zoom, take a moment to answer this question. And for those in person, who thinks stairs and no ramp is the disability? Okay. All right. How about being unable to walk? Okay. How about the wheelchair? All right. How about being unable to levitate? Okay. Okay. So for this one, the stairs and no ramp is actually the disability in this circumstance, because the stairs and no ramp is the environmental barrier preventing the person using the wheelchair to go up whatever it is the accommodation that's up those stairs. So stairs and no ramp is the disability. And so you can pull up the last question, please. Thank you so much. So what is the impairment? And so who thinks stairs with no ramp is the impairment? Okay. How about being unable to levitate? Yeah. Nice. Cool. All right. How about the wheelchair? All right. And then how about being unable to walk? Who thinks that's an impairment? Cool. Okay. So yes, being unable to walk is the impairment. And I see a lot of us got picked up on that. So being unable to walk is the condition that is consistent with the impairment. And so that is our exercise on impairment versus disability. And I will turn it back over to Conrad.
Yeah. All right. Thank you, Dustin. And thank you, everybody, for participating. So next, I would like to get into 3 models of understanding disability. And there are many other models out there, but these are probably the 3 predominant ones in Western society over the last few centuries. So first, starting with the moral model of disability. So this is generally an older conception of disability and refers to the attitude that people are in some way morally responsible for their own disability. For example, the disability may be seen as a result of bad actions of parents, if congenital, or as a result of things done by the individual so as to make them, quote unquote, deserve their disability. And echoes of this can be seen, for example, in the idea of karma. And then more recently, there's been the medical model of disability. And the medical model is presented as viewing disability as a problem of the person that's directly caused by some sort of disease, trauma, or other health condition, and requires medical care and treatment by professionals. And so in the medical model, management of the disability is really focused on, curing or fixing the individual, quote unquote. And in the medical model, medical care is really viewed as the main issue. And at the political level, the primary response is through measures that treat more individuals and do seek better health outcomes, which in and of itself is not a bad thing. However, unfortunately, historically, the medical model has also been a driving factor behind many of the terrible practices of negative eugenics that were seen in the 19th and 20th centuries, and surmised in the Supreme Court decision of Buck v. Bell. And so more recently, there's been the social model of disability. And the social model of disability sees the issue of disability as primarily a socially created problem and a matter of the full integration of individuals into society. Under this model, the disability is not necessarily an attribute of the individual, but is rather a complex collection of conditions, many of which are created by the social environment, as we kind of alluded to in the disability studies definition of disability. So as a result, the management of disability on a societal level requires social action and is the collective responsibility of society at large to make the environmental changes necessary for people with disabilities to be able to fully participate in society. And so the issue is both cultural and ideological, and requiring individual, community, and large-scale change. And it's really about taking us from the paradigm of the medical model and getting us to more of a social model, and getting away from the idea that, there's something wrong with the individual for having a disability, and that, the individual needs to be changed to conform to society. And so people in the past have asked, what's wrong with you, and not what's wrong with society of people with disabilities. Okay, next slide. I think we went one too far there. There we go. So over the last 40 years, we've made some progress. So 40 years ago, there were stairs everywhere, curbs everywhere, people were homebound. We had typewriters and pens. All this is more like 50 years ago now, but widespread discrimination did not have a legal remedy, and accessibility was really an afterthought at that point. However, today we have ramps and lifts. We do have more and more curb cutouts, modified vans and buses. You know, we have programs such as Dragon Naturally Speaking for speech to text. Then we have legal protections such as the ADA. And then also the idea of things like universal design. Okay, next slide. So now on to those misconceptions. So next slide, please. Let's start with a few interesting examples of supposed access. Okay. All right, so here's the first one. And I should preface this by saying that these are going to be several particularly inaccessible locations to highlight just how far some people and places still have to come, because these are real places. So starting with this first one here. So here we have what is supposed to be passing as a ramp, curving at nearly 90 degrees up 5 steps. And so, as you can see, the ramp is split in the middle and has 2 very narrow sides that apparently wheels are supposed to fit on. And that it looks like they did try to make it slightly less horribly dangerous by building up the concrete along the outside of the ramp to provide some sort of protection along the edge. Next slide. All right, next we have what is supposed to be an accessible crosswalk. And, you know, I always give credit where credit is due, so it's worth pointing out that the curb cutout itself is highly visible. And the blue and white paint make it quite clear what is supposed to be happening here. However, that's where the compliments end. As you can see, there's a sizable median in the middle of the crosswalk that does not have any path through. So apparently you have to go all the way around and off camera to try to find your way around it. And the additional thing that's barely visible, and bonus points if anybody can see it, are the yellow posts at the end of the crosswalk that may very well prevent you from fitting through with a wheelchair. And so imagine finding out that little fact and then needing to turn back around and repeat the harrowing adventure. Okay, next slide. And last but not least, finally, this is an attempt at an internal ramp. And the one thing that it does have going for it is that it does have a sizable landing area in the middle. However, it does not provide the necessary edge protection to prevent wheels, feet, or various appendages from going off the edge under the railings. However, those are obviously very minor compared to what happens at the bottom of the ramp. Not 1, but 2 full-size steps. So maybe they expect a wheelchair user to get enough speed going maybe they'll stick it at the bottom of the landing. I don't know. So before I get to the next part of this, these are all indeed real examples of particularly ridiculous inaccessibility, but they're mostly intended as an entertaining warm-up exercise. So now I'm going to hand it over to Dustin in a second here to move on to 6 particularly common ADA myths that much of the general population does not realize are just that. Myths. Education is empowerment, as they say. So let's bring them and the facts necessary to debunk them to light.
All right. Thank you very much, Conrad. And so we will discuss 6 common myths. There are next slide, please. So myth number 1, ADA employment suits are overwhelming the courts. Fact, last year in 2021, 22,815 charges of disability discrimination were filed with the Equal Employment Opportunity Commission, the EEOC. Now, 22,815 is tiny compared to the millions of businesses, hundreds of thousands of public and private employers, and the tens of thousands of units of state and local governments that are required to comply with the ADA. So 22,815 compared to all of those actors is a pretty tiny number. Next slide, please. Thank you. Myth number 2. People with disabilities win most of their cases against employers under the ADA, which results in employers paying out massive awards. Fact, the EEOC in 2021 awarded EEOC awards to people with disabilities last year only totaled about $122 million nationwide in all of 2021. So that's myth. Next slide, please. Myth number 3. The ADA, along with other laws such as the Family and Medical Leave Act, the FMLA and Workers Compensation, especially hurts small businesses who cannot afford human resources staff to advise them on legal requirements. Fact, small businesses with fewer than 15 employees are not covered by the ADA, and the FMLA only applies to employers with 50 or more employees. The ADA provides an undue hardship defense against reasonable accommodations that are unduly costly or burdensome. Smaller employers can more easily establish undue hardship because smaller employers have fewer resources for accommodations. Next slide, please. All right, myth number 4. Oh, and by the way, notice the photo here. You have the toilet attached to what looks like the doorway with the toilet paper also attached to the doorway in this pretty extreme example here. But myth number 4, the ADA is rigid and has excessive requirements for making existing existing facilities accessible. Fact, the ADA it's all about common sense. The ADA recognizes that altering existing structures is more costly than making new construction accessible. The ADA only requires that places of public accommodation remove architectural barriers in existing facilities when it is readily achievable. Readily achievable means that removing such barriers could be done without much difficulty or expense. Quick and easy steps that can be taken include, for example, ramping a step or installing a bathroom grab bar, maybe not directly attached to the door like in that photo right there, or lowering a paper towel dispenser, that's another example, or rearranging furniture, installing offset hinges to widen the doorway, or painting new lines to create an accessible parking space. Next slide, please. Myth number 5. The ADA requires that sign language interpreters for all situations that involve persons who are deaf and is inflexible. And by the way, notice this picture right here is taken at a restaurant in Washington, D.C. Here we have looks like a customer attempting to learning a sign language from employees of the restaurant. Again, that's another extreme example. But the fact here is that the ADA only requires that effective communication not exclude people with disabilities, which in many situations can mean providing written materials or exchanging notes. The law does not require anything that would cause an undue financial or administrative burden. Next slide, please. All right, myth number 6. The ADA requires extensive renovations of all state and local government buildings to make them accessible, and this is a heavy toll on budgets. That's a myth. The fact here is that the ADA requires all government programs, not all government buildings, but requires all government programs to be accessible. Program accessibility is a flexible requirement and does not require a local government to do anything that would result in an undue financial or administrative burden. Local governments, in fact, have been subject to this requirement for many years under Title V of the Rehabilitation Act of 1973. Not every building or every part of every building needs to be accessible. Structural modifications are required only when there's no alternatives available for providing program access. So, for example, a school has an inaccessible second floor, and so no elevator is needed if the school has program accessibility for people using wheelchairs, for example, by having a class move to, for example, an accessible first floor that doesn't need an elevator, for example. And so these are 6 common myths about the ADA. And now I will turn it back over to Conrad to discuss why these myths matter.
All right, thank you, Dustin. So why myths matter? There is a particularly pervasive and harmful perception that there is such a thing as widespread ADA lawsuit abuse, particularly regarding physical accessibility at places of public accommodation. In some states, such as California and Arizona, a small number of attorneys and plaintiffs are litigating a significant number of ADA access lawsuits across these respective states. And some special interest groups in particular, including the shopping center's lobby, claim that this is excessive and abusive. And I will acknowledge that there are instances where this has been taken to an extreme degree and unethical practices have occurred. However, on the whole, I need to be clear that ADA lawsuit abuse is based in myth more than fact. And still, to this date, only approximately 2% of places of public accommodation are completely ADA compliant. And so more enforcement rather than less needs to be encouraged, in my opinion. Unfortunately, as a result of this lobbying in recent years, Congress has considered legislation which would severely limit private enforcement of the ADA through strict notification and cure requirements. And so one bill that was introduced that did not pass would have even included criminal penalties for not following the exacting demand letter requirements. And the bill would have required a person with a disability to give the business owner who has an accessibility barrier, one or more of them at least, written notice, 60 days to even acknowledge that there's a problem, and then another 120 days to even begin to fix it. And I'd like to point out that no other constitutionally protected group of people is forced to wait 180 days to enforce their civil rights. Next slide. So let's get to the spirit of the ADA before we get to the letter. So here's a quote that I like to share from the late Dustin Dart Jr., who was a Texas oil man who actually then became one of the key proponents with getting the Americans with Disabilities Act passed. So I'll read the quote as well, but most importantly, the ADA is a landmark commandment of fundamental human morality. It is the world's first declaration of equality for people with disabilities by any nation. It will proclaim to America and to the world that people with disabilities are fully human, that paternalistic, discriminatory, segregationist attitudes are no longer acceptable, and that henceforth, people with disabilities must be accorded the same personal respect and the same social and economic opportunities as other people. Next slide. Okay, so getting into brass tacks here. Who and what does the ADA cover? So the ADA has a number of titles. I'm going to go through 5 of them. And so Title I covers employment. Title II covers state and local governments and transportation. Title III covers public accommodations or businesses primarily. Title IV, telecommunications. And Title V, miscellaneous. And there's actually some really important provisions in there. So going a little deeper, Title I protects qualified applicants with a disability from discrimination in employment. Title II is designed to protect people with disabilities in all services, programs, and activities provided or made available by state or local governments and their affiliate agencies, such as public schools, government meetings, transportation services, and public recreation facilities, among others. And then Title III, at its core, states that owners of previously existing public accommodation facilities must remove physical barriers to accessibility when it's readily achievable to do so. And then Title IV, with telecommunications, requires accessibility in services such as relay services, TDD, and closed captioning. And then that miscellaneous Title V, it includes miscellaneous provisions and covers things such as state immunity from suits for damages and the payment of attorney fees. And it further states that the federal government can sue states and assess financial penalties for non-compliance with the ADA. Further, it protects people with disabilities from retaliation when an ADA complaint is filed. And it also states that stricter non-discrimination laws will always apply in states that have enacted those. And there are a number of states that have enacted even stricter accessibility requirements, such as Hawaii and California. Not our state, however, unfortunately. Next slide. Okay, so the ADA and accessibility. So really at its core with Title II, entities must achieve program accessibility. And then Title III is focused on barrier removal or alternatives in existing public places. And I guess it's important to understand at a high level that Title III, which covers businesses, is actually more exacting than the requirements covering the government. So take from that what you will. And so really there's a hierarchy of obligations here. And so the ADA accessibility guidelines were developed for new construction and alterations. So new construction must be fully accessible and in full compliance with the applicable ADAG, as they're referred to, provisions. And so alterations must observe the ADAG new construction criteria when it's technically feasible, and less stringent technical specifications may be applied where it's technically infeasible. And so alterations to the primary function areas, so whether it's the restrooms or assembly areas, for example, has the additional obligation to improve the path of travel, because if you can't get there, then what's the point of making it accessible? And so existing facilities must achieve a level of usability that balances user needs, the constraints of existing conditions, and the resources available to do the work. But the key takeaway here is that new construction needs to fully meet the accessibility standards. Okay. Okay, so going deeper into Title I, the ADA states that covered entities cannot discriminate against a qualified individual with a disability. And so this applies to the gamut of employment, running from job application procedures, hiring, advancement, firing, training, everything you could imagine related to employment. And so an employer under Title I is generally considered any employer that's engaged in interstate commerce, so pretty much anyone, and having 15 or more employees. And so some examples of discrimination might include limiting or classifying a job applicant or employee in an adverse way, denying employment opportunities to people who truly qualify, not making reasonable accommodations to known disabilities, or not advancing employees with disabilities, or providing the needed accommodations in order to advance. Next slide. Okay, Title II now. So basically, Title II applies to anything a public entity does. Coverage is not limited to executive agencies, but also includes the legislative and judicial branches of state and local governments. And notice that I said state and local governments. Believe it or not, the ADA does not apply to federal courts. And so there's a bit of irony there. All governmental activities of public entities are covered, even if they subcontract those out. A public entity does not have to take any action that it can demonstrate would result in a fundamental alteration in the nature of its program or activity, or an undue or financial administrative burden. And as far as enforcement goes, private parties can bring lawsuits to enforce their rights under Title II. So the takeaway rule here with Title II is that to show a violation, a plaintiff must demonstrate that they are or represent the interests of a qualified individual with a disability, that the individual was either excluded from participation in or denied the benefits of some of the public entity's services, programs, or activities, or was otherwise discriminated against, and that such exclusion, denial of benefits, or discrimination was by reason of the individual's disability. Next slide. Okay, and then on to Title III. So Title III covers public accommodations. These include commercial facilities, so non-residential facilities such as office buildings, factories, warehouses, whose operations affect commerce, and public accommodations, for example, that offer certain examinations and courses. However, Title III does not cover entities that are controlled by religious organizations including places of worship or private clubs,
She gets on when she gets going.
except, I think we're having a little sound issue here. There we go. Private clubs, except to the extent their facilities are made open to the general public. So, for example, the Masonic Lodge, if they have meetings that are private, those meetings would not have to be accessible. However, if, for example, they rented out the space to the general public, then to the extent that individuals from the public are using the space, it does need to be accessible. Okay, next slide. Under Title III, public accommodations have 3 mandatory areas of obligation. They are required to operate in a non-discriminatory way so that individuals with disabilities have the same opportunities to participate in and benefit from everything that it provides to customers. To ensure that communication with individuals with disabilities is as effective as with others, including when necessary, providing auxiliary aids and services when necessary to eliminate communication barriers, and to provide accessibility by removing barriers in existing facilities when removal of barriers is readily achievable. So again, accomplished with little difficulty or expense in relation to the resources of the entity, providing alternatives to barrier removal when modifications to remove barriers are not readily achievable, and providing accessibility in all renovations, alterations, or additions to facilities and/or construction of new facilities by complying with the ADAG standards that we referred to earlier. Next slide. Okay, so the limitations on Title III obligations. Title III or other, I should say, other than what we already included with religious entities and private clubs. Title III entities are not required to change their policies and/or procedures in any way that would fundamentally alter the nature of goods or services offered, would undermine the safe operation, would pose a direct threat to health or safety, or would constitute an undue burden. So now we need to consider, what is a fundamental alteration? What would undermine safe operation? What would qualify as a direct threat? What would constitute an undue burden? Next slide. Starting with a fundamental alteration. That would be a change that is so significant that it alters the essential nature of the goods, services, facilities, privileges, advantages, or accommodations offered. So let's get into an example. Someone who is deaf asked that the lights in a planetarium be raised so that he could see his interpreter. Of course, this would fundamentally alter the experience for everyone, including the person who asked. However, even though the planetarium could, and probably did, deny this request, the planetarium still has obligations under the ADA. One possible solution would be to offer the patron a seat off to the far right or far left and position the interpreter with a dim light in front of them. Another would be to provide them with the narrator's script and a small light. Another example would be a restaurant is not required to prepare special dishes for customers who have disabilities. That too would be a fundamental alteration in the nature of the restaurant services. However, if it is easy to omit a sauce or ingredient from a dish that's listed on the menu, a customer can request that the item be omitted. That would not be a fundamental alteration. Next slide. Okay, what would undermine the safe operation? So people with disabilities can't be excluded from a service or be segregated from other customers unless necessary to ensure the safe operation of a business. If legitimate safety requirements necessitate exclusion or segregation of a person with a disability, it must be based on actual risks, not on stereotypes or generalizations about people with disabilities. Staff are not expected to abandon their duties in order to provide assistance to a person with a disability when doing so would jeopardize the safe operation of a business. For example, a Grand Canyon River Raft Tour company may require all participants to take a swim test in order to participate in a rafting expedition. Even if some people with disabilities might not pass the test, the policy is legitimate because the actual risk of harm to people who would not be able to swim to safety if the raft capsized. However, the same company may not refuse to take customers who have disabilities based on the incorrect belief that people with disabilities just can't swim. Conversely, the company may not require only people with disabilities to take a swim test based on the assumption that people who don't have disabilities all know how to swim. Next slide. What would qualify as a direct threat? A direct threat is a significant risk to the health or safety of others that cannot be eliminated. A dentist, for example, cannot refuse to treat a patient who has HIV and refer him or her to elsewhere if the dentist offers other patients the same service that is being sought by the patient with HIV. HIV does not present a direct threat to dentists who follow universal precautions. The key inquiry in direct threat analysis is whether the employer's belief about the direct threat imposed by an employee's disability is reasonable, not whether the threat actually exists and can be proven. Next slide. What would constitute an undue burden? So that's defined as significant difficulty or expense and is sometimes a challenging determination. It depends on a variety of factors, and the standard is intended to be applied on a case-by-case basis. It's not measured by the amount of income the business is receiving from the individual. Instead, undue burden is measured by the overall financial impact on the entire entity. An undue burden means significant difficulty or expense. In determining whether something would result in an undue burden, here are some factors to consider. The nature and cost of the action needed, the overall financial resources of the site or sites involved, And those include a variety of other kind of sub factors, including the number of people employed at each site. The geographic separateness and administrative or financial relationship between the sites in question and any parent corporation or entity. If applicable, the overall financial resources of any parent corporation or entity, which includes the size of the parent corporation or entity with respect to the number of employees, the number, type, and location of facilities. And then if applicable, the type of operation or operations of any parent corporation or entity, including its composition, structure, and functions of the workforce of the parent corporation or entity. Okay, next slide. So a quick mention of Washington Civil and Disability Advocate. So our organization provides legal representation with a focus on accessibility cases, although we do some employment discrimination and civil rights. We provide information and referral services, including low and no cost services and connections to disability service providers. And then we also provide education outreach, such as this presentation today. Okay, next slide. So that concludes the primary portion of our presentation today. And here you can find more information. All right, so that's it for the main part of the presentation, but I wanted to provide plenty of time for Q&A as well. And so if anyone has any questions, I'm happy to go into those. Okay, starting with the leftmost here.
My first question, microphone. My first question as I was listening to you was, how does airplanes fall into that? I mean, they don't seem to be accessible in any way, shape, or form, but yet there's a lot of accessibility at the airport, but not so much on the plane.
I'm glad someone else is noticing that as well. And so it's interesting, actually, that airlines are covered under an entirely different law than the ADA. The Air Carrier Access Act, which was passed in the early 80s. And unfortunately, under that, there's no private right of action whatsoever. And so a person with disability who faces accessibility issues or discrimination, they can't actually file a private lawsuit and instead rely entirely on a Department of Transportation complaint, which clearly hasn't gone very well. And I will point out also that there used to even be a cap on damages to wheelchairs. And so at one point, I think, despite the fact that wheelchairs are very expensive, it was something like the $500 cap. And so even if they totally destroyed the chair, that's all they were on the hook for. But there are efforts to pass a new law that would catch it up to the ADA, the Air Carrier Access Amendments Act, which hopefully will get some traction, but the airline lobby does have a lot of money. So we'll see what happens. Although there's a lot of research going into making it safe, for example, to have it so someone in a power chair can just drive on the airplane. Because that's where a lot of the challenges occur, is with getting a power chair loaded under the plane safely without it getting wrecked in the process. And then, the last thing somebody wants to do is fly across the country and then have half a wheelchair. Okay, next question. We'll just keep going and yeah.
Well, I want to thank you very much for the presentation. I wonder if I could hear from you about what you see as the greatest challenge in disability rights litigation today. And as I think about that, I think about the slide you showed, kind of showing the progress over the last 40 or 50 years, kind of what you see as the greatest challenge in your area of practice today. Thank you.
Sure, I'd say websites. That really is, I guess, the hot area of ADA litigation right now. And both on the plaintiff side as well as the defense side, everybody is really wanting more guidance on what's covered under the ADA. Because right now we have a pretty intense circuit split that runs all the way from no websites are covered under the ADA to pretty much all websites are covered, and then everything in between. And then in the Ninth Circuit, we have something that is basically referred to as the nexus test. And so there needs to be a physical nexus, as the court's referred to, between like the website and a public place. And so, for example, that would mean that like Netflix or eBay, things like that, the Ninth Circuit has said don't fall under the ADA. But if you have like Ticketmaster and their ticket sales site for the Seahawks, let's say, not to refer to a case we've had before, that does fall under the ADA because there's a physical nexus. And so I think everybody's looking for more guidance because the ADA itself is not particularly clear as far as when websites fall under the ADA, when they don't, because it was really passed before websites were much of a thing anyway. And so I'd say that's probably the really kind of standout challenge at the moment.
Governor Angelville had her virtual hand up.
Thank you. And thank you so much for your presentation. This is a really interesting topic, but it's also an important one. And it's great to learn about some of the issues. My question is regarding our own state courts. What mechanism is there to ensure that the courts are ensuring access?
Okay, so as I was mentioning before, while unfortunately federal courts do not fall under the ADA, courts at the state level do. And there actually are requirements under these ADAG standards that cover just courthouses and cover exactly what needs to be done to make them accessible. And so plaintiffs are free to litigate those cases if necessary if a court is not accessible at the state or municipal level.
Thank you.
Anybody else have any questions for our presenters?
I might have gotten something in the chat. I'm not sure there. I see a.
Yeah, I think that was an old link of
Okay.
a former presentation.
Okay, cool.
All right. Well, thank you so much. We've had a series of presentations over the course of the last year, and all of them have been very good. And we add this one to the very impressive presentations and educational opportunities for us. So thank you so much for coming.
All right, thank you.
We're going to take a 10-minute recess. We haven't had a recess this afternoon yet. So 10-minute recess. So we'll reconvene at about 3:33.